Welcome to our comprehensive journey through the customary land law of Ghana. In this first part, we are going to explore the foundational concepts of land ownership, what actually constitutes land, and the unique characteristics that make it so vital to society.
Ghanaian land law is fascinating because it is a hybrid system. You will find English common law principles operating right alongside traditional Ghanaian customary rules, constitutional provisions, and statutory laws. This coexistence can sometimes make property rights complex.
For our purposes, customary law is incredibly important. Article 11 of the 1992 Constitution specifically recognizes these rules of law, which apply by custom to particular communities throughout Ghana.
Before we dive deeper, we must distinguish between movable and immovable property. Immovable property refers to the land itself and any rights or interests attached to it. If someone takes it, the court can restore the actual property to you.
Movable property, on the other hand, includes things like vehicles, cash, or even debts. If these are taken, your legal remedy is usually a personal action to recover the item or its monetary value, rather than an action against the land itself.
So what exactly is land? Under the Conveyancing Act, it is not just the dirt on the ground. It includes land covered by water, any buildings or structures, and the space above and below the surface.
This means a landowner's rights extend to a reasonable height above the property and below the surface. However, in Ghana, minerals found in their natural state are constitutionally vested in the president in trust for the people.
Land has several unique characteristics. It is indestructible and permanent. You can degrade it, but the land mass remains. It is also fixed in location, meaning every single plot can be precisely mapped and described by surveyors.
Because of its limited supply and permanence, land is highly sought after as a secure investment. It is the primary capital asset upon which the survival and economic prosperity of the human race depend.
Here is a profound principle of Ghanaian customary law. There is no such thing as ownerless land. Every single inch of land in Ghana is vested in somebody, whether it is a paramount stool, a family, or an individual.
Even if a piece of land is completely unoccupied or lying fallow as a dense forest, it still has an owner. Anyone who steps onto that land without permission is committing trespass. Now, let us move forward and look at how people actually interact with and possess these lands. Picking up right where we left off, let's look at compulsory acquisition. Under the Administration of Lands Act, the President can authorize the use of stool lands for public welfare. For non-stool lands, the State Lands Act applies via an executive instrument. Once that instrument is published, the land vests in the state free from encumbrances. Affected parties must claim compensation, which is calculated based on market value and the cost of disturbance for relocating. Now let's shift to a fascinating debate. Historically, colonial judges assumed that there is no land without an owner in Ghana, believing all vacant land automatically belonged to the nearest stool. However, legal scholars like Professor Kludse heavily critique this. He points out that in many non-Akan communities, stool ownership of land is unknown, meaning genuinely ownerless lands can and do exist until a family occupies them. Moving on to leases. A lease is created when someone grants a specific portion of their interest in land to another for a fixed term. The grantor is the lessor, the receiver is the lessee, and the interest left behind is the reversionary interest. This creates two vital relationships. Privity of contract arises from the actual agreement between the parties, while privity of estate comes from their shared simultaneous interest in the land itself as landlord and tenant. Even if not explicitly written, the Conveyancing Act implies certain covenants in a lease. For instance, the lessor guarantees the right to convey the property and ensures the lessee's play at enjoyment of it without interference. In return, the lessee impliedly covenants to pay rent, allow the landlord to repair adjoining premises if necessary, and avoid causing a nuisance or using the premises for illegal or immoral purposes. What happens to things attached to the property? The rule is quidquid plantator solo, solo sated. Whatever is attached to the land becomes part of it. The key tests to determine a fixture are the degree and the purpose of the annexation. But there are exceptions. To encourage business and comfort, the law allows tenants to remove certain fixtures at the end of their lease, specifically those installed for trade, ornamental, or agricultural purposes. Leases don't last forever. They naturally end through the afflection of time. They can also end via surrender, where the tenant gives the lease back, or merger, where the tenant actually acquires the landlord's reversionary interest. Then there is forfeiture, where a landlord terminates due to a breach.
However, under Section 29 of the Conveyancing Act, the landlord cannot just re-enter the land. They must serve a written notice and give reasonable time to remedy the breach. Finally, let's briefly look at tenancies, which are generally shorter than leases. We have periodic tenancies, which renew automatically from month to month or year to year, and tenancies at will, which have no fixed duration. We will explore the mechanics of these tenancies in the next segment.
Moving right into the next phase of tenancies, let's look at what happens when a lease ends. A tenancy at sufferance occurs when a tenant lawfully enters but wrongfully stays after the lease expires, without paying rent. Contrast this with a statutory tenant. Here, the lease expires, but the law steps in to protect the tenant's possession as long as they continue paying rent on a monthly basis.
The Rent Act of 1963 is the primary law governing these relationships in Ghana, but it doesn't apply to everything. It strictly covers situations where rent is paid, meaning statutory and periodic tenancies are included.
However, the Act expressly excludes bare land, customary tenancies like abunu and abusa, and government-owned duty posts provided to public officers. A major protection under the Rent Act involves rent advances. For a monthly tenancy, landlords can lawfully demand only 1 month's rent in advance. For longer tenancies, the maximum advance is 6 months. Demanding years of rent up front is not just unlawful, it is actually a criminal offense under Section 25, punishable by a fine.
To enforce these rules, the Act establishes 2 key authorities. First, the rent officer investigates complaints, assesses recoverable rent, and inspects premises. However, the rent officer cannot order an eviction. That power belongs exclusively to the rent magistrate, who hears appeals from the rent officer and makes legally binding ejectment orders.
Landlords also have strict statutory obligations. For instance, they must issue a rent card within 7 days of the tenancy starting, detailing the parties and the recoverable rent.
They must also compensate tenants for approved improvements if asked to leave early, and they are responsible for controlling unauthorized subletting on their property.
So, how does a landlord lawfully recover possession? Section 17 of the Act outlines specific grounds. The most common is non-payment of rent, which comes with a mandatory 1-month grace period.
Other grounds include breaking a lawful obligation in the lease or engaging in conduct that creates a nuisance or annoyance to adjoining occupiers.
Landlords can also evict tenants if they are formally convicted of using the premises for immoral or illegal purposes, such as running a brothel.
Additionally, if a tenant's neglect or intentional damage causes the property to physically deteriorate, known legally as waste, the landlord has grounds to recover the premises.
What if the landlord just needs the space back? They can recover a dwelling for personal occupation or for a family member, provided they prove it is reasonably required and pass a greater hardship test.
For business premises, the landlord must give a 6-month written notice and genuinely require the space for their own business. We will explore the remaining statutory grounds for eviction in the next segment.
Under the Rent Act, specifically Sections 25 and 28, a court can order the ejectment of a tenant if they are convicted of specific offenses, like illegally demanding a premium or goodwill. Under common law, a landlord can also recover possession simply if the tenant denies the landlord's title.
Landlords also face strict criminal liabilities. For instance, they cannot demand more than a month's rent advance for short tenancies, or 6 months for longer ones. It is also a criminal offense to induce a tenant to quit by cutting off their water or electricity. Even administrative failures, like not issuing a rent card within 7 days or failing to provide a written receipt for rent payments, can result in fines or imprisonment under the General Offenses section of the Act.
Shifting our focus to customary land law, families hold significant allodial and usufructuary interests in Ghana. Depending on the region, these families trace their descent either matrilineally, through the mother, or patrilineally, through the father, which dictates how property is inherited.
A crucial concept is how privately acquired property can transform into family property. If a family substantially contributes labor or funds to develop a member's land, or if a member dies intestate without successors, the law can automatically vest that property into the wider family. When it comes to alienating or selling family land, the head of family is an indispensable figure. However, they cannot act alone. They must have the consent and concurrence of the principal members of the family, usually obtained during a formally convened family meeting.
Seriously, if the head of family alienates land without the principal members, the transaction is merely voidable, meaning the family can act timelessly to set it aside. But if the principal members try to sell without the head of family, the transaction is completely void from the start.
Generally, only the head of family can sue to protect family property, but the landmark case of Kwan versus Nyeni established exceptions. If the head is squandering property, or if there is a division preventing action, any member can step up to litigate out of necessity to preserve the estate.
How does one become the head of family? It is not an automatic right. A person must be formally appointed, elected, or widely acclaimed by the principal members. In the absence of this, the oldest member may act. Their duties range from managing land grants to settling internal disputes.
Historically, under customary law, the head of family was not legally accountable to members for their stewardship. The only remedy was deposition. But this changed dramatically with the Head of Family Accountability Act of 1985, which legally compels the head to file inventories and render accounts.
That wraps up our comprehensive look at Ghanaian property law. We have covered the strict statutory rules governing landlord liabilities, the intricate customary laws of family property management, and the modern statutory accountability of the head of family. Keep these principles in mind as you review your cases.